OregonDefense.com and the law office of Justin Rosas. I'm Justin Rosas. I've been practicing in Oregon and throughout the country in federal court for the last 17 years, and I'm honored to be a criminal defense attorney. Today we're going to talk about the Oregon Sentencing Guidelines Grid, and that's going to involve a little bit of a history lesson about the National Federal Sentencing Guidelines, which we will come back and talk to later. It's really important to think about the guidelines if you or someone you love has been charged with a crime in the state of Oregon, particularly a felony, which is what the grid is for. And it's important to have some understanding of the way that the guidelines work so that you have the ability to better predict what may be the outcome, especially an unfavorable outcome at trial. The Oregon Sentencing Guidelines Grid, at least the version of it that criminal defense lawyers use, looks like this. The grid obviously is this part. What you see down here is a lot of alphabetical listings of felony charges that give you the crime seriousness category that those have been classified as by the legislature. So I want to take you back real quick to kind of understand this before we move into the specifics. So if you could think back to the late 1980s, early 1990s, the federal government, you might imagine, being caught with drugs, particularly being a brown person caught with drugs in the deserts of Arizona or Texas, you were in an immense amount of trouble and likely to be sentenced to an incredibly lengthy time in prison. Being caught maybe with a gun or a gun operation in those areas, particularly being a white person, maybe illegally trafficking guns in those areas, you were in a much better situation than you would be in some other courts. Transpose that to New York City, where there's a lot more trauma-informed understanding and a lot more leniency built into their drug laws, however, treating gun laws very severely. The idea of that inequality in sentencing led to a push for the federal sentencing guidelines. Now, it's not that it led to a push for the federal sentencing guidelines in order to give more gracious sentencing or to keep people away from the brutality of the criminal justice system as it was. Quite the opposite. If you recall, just thinking about history in the late 80s and early 90s, you're talking about a time period where super predator was a term that was used by the news all the time. Mass incarceration was at its largest numbers and growing exponentially throughout both the Reagan W and Clinton administrations. The building of prisons, the increase in district attorneys' offices, and the large number of police that were added to the forces in order to fight the war on drugs and in order to feed into the public's sense of fear over crime at the time meant that the sentences were actually becoming uniformly brutal, more so than uniformly lenient. State of Oregon, if you want to think about us, same time frame, you can imagine being out in Lakeview, Oregon, rural Oregon, Eastern Oregon, being caught with a gun that you shouldn't have, probably going to be relatively lenient. Being a mule in a drug operation that runs from Mexico to the United States and being caught out in Lakeview, you're very likely to be in a whole lot of trouble. Transfer it up to Portland, you can see how those things flip, how a gun is more likely to be treated seriously in Portland, and how drug trading is more likely to be at least understood and sentenced under a different rubric in Portland. So the state of Oregon is like, we don't want to be the little brother to the federal government here. We're going to invent our own sentencing guidelines. And the legislature, with the Criminal Justice Sentencing Commission, basically got together and started to rank crimes. Those crimes got ranked from 1 to 11. 1 was things back in the day like possession of a controlled substance, which is now no longer a felony. But to give you an example of a one that makes me laugh, bigamy. So having more than one spouse is a level 1 felony still in the state of Oregon. We can talk through that sometime too, but pretty odd that we have bigamy on the books. And then 11, the only 11, I believe, is murder. And so as you can see, going up the grid, you don't want to be going up the grid. So the Sentencing Commission sat around and they tried to think of what the criminal justice seriousness score should be for each felony charge. There are times when someone's charged with a crime and it could be one of a number of different crime seriousness categories. And you see those actually on the back of this chart. So a criminally negligent homicide that involves a DUI is more aggravated than a criminally negligent homicide that does not involve a DUI. We all are somewhat aware too of the quantity amounts with drugs. So the more quantity that you possess, the higher the crime seriousness category of the felony which you'll be charged. For property crimes, theft, identity theft, aggravated theft, it's all about the value of the item. And there's some ways in which maybe that's not the best guidance for determining how aggravated a theft is, but that's how the crime seriousness categories rank for thefts. People then get ranked from I to A. You want to be an I in this equation. An I is somebody with no criminal history. An A is a person with at least 3 or more person felony convictions. Person felonies are things like assaults, burglaries where someone's home, something that invades the sanctity of our bodily personhood, not just invades, private property rights or dealing of drugs, etc. Each person misdemeanor, so things like resisting arrest or assault in the fourth degree, which are misdemeanors, actually count 1/2 of a person felony conviction. But a person can have a person felony conviction without being a felon. A person can actually have 3 person felony convictions without being a felon if they had 6 qualifying misdemeanor convictions. And that's why it's important to get a lawyer's advice about your specific criminal history and where your grid score is. Each category is based on different sort of criteria, no more than 3 misdemeanors, and no felonies, 1 felony, the 4 felonies, and then it moves along the side of the grid. So what you would do then is you would triangulate. So you would say you're charged with a level 6 witness tampering offense, and you have only 1 prior misdemeanor. You're an H, so you would be a 6H. And you would triangulate to that section to find out not what your sentence definitely is, but what it's presumed your sentence would be. There's ways to argue down from this, and there's also ways to argue up from this. Limited more so in ways to argue up than down in most occasions. But it's kind of to give the judge an idea of what the sentence should be. Now you can see all these yellow quadrants, yellow grid blocks here. All of those represent sentences that are technically prison sentences. So those are months in prison that you would see within the grid. And we'll post the grid on the article and the website as well. The green, purple, and fuchsia pink blocks are all presumptive probation grid blocks. So those look like higher numbers, but actually are different. Those are, you take the bottom number and you divide it by 3. Don't ask me why they set that the way it is. That's the administrative rule. And that's the number of days of jail or house arrest that the court would most likely impose up front. And then the remaining number of days that are there would be the days that a probation officer could use if you were not completing your probation. You see this category here is the probationary term. So that's where you'd look to see like how long is the probation if I get probation for this level offense. And then far over here is the post-prison supervision term. So that's parole if you get out of prison. So if you do get one of the yellow grid blocks, how long would your post-release supervision be? You see these 3 grid blocks colored a more muted tone of yellow. Those are because those are optional probation grid blocks, meaning that the court is really supposed to look, even though they're prison sentences, at whether or not the person qualifies for optional probation, meaning that there's a treatment program available in the community, that treatment program will be more likely to address recidivism or the re-offending than a sentence of incarceration, and that the defendant can be admitted into such a program. So on those grid blocks, it's sort of built in that you're likely, I don't know, likely is probably strong, but that you're more likely than in other situations to be able to get a downward departure to probation, even though they're yellow grid blocks. Now, up here at the top is a box that sort of stands out, and we'll have another video to talk about this completely, but that's measure 11. So if your crime that you're charged with or your loved one is charged with is listed in this box, that means it has a mandatory minimum prison sentence if you are convicted of that offense. The mandatory minimum prison sentences are listed over here. It takes it sort of off the grid block, ignores your loved one's record or lack thereof, and says we require a mandatory minimum sentence for these types of cases. Again, we'll talk about that in another video and talk about ways to get around, mitigate, defend, and defeat Measure 11 cases. But that's what is here on the grid, and that's something that takes things off the grid and into a different realm. The other thing you need to know, many people come and they ask me about suspended sentences or dispositional departures. They feel like they're likely to be convicted of something. They're trying to avoid the brutal and dehumanizing prospect of going to prison. Prison obviously rips families apart and does not help with problems, and instead only seeks to perpetuate a culture of violence against people rather than understanding and bringing them towards justice. So how do I get a downward departure? How do I avoid a prison sentence? And there are downward dispositional departure factors that are listed actually on the back of the grid, including that the offender played a minor role, that the harm was less than typical, substance abuse or addiction issues, mental health issues, the fact that someone served in the military. There are the court can downward depart for almost any reason. And so building a mitigation case to argue for a suspended sentence or a downward departure is a huge part of what attorneys do, trying to get around mandatory minimum sentences to a point where they can then argue for a probationary sentence and show the court that you or your loved one is not a risk to be in the community and instead may have a health problem or may just need a little bit of guidance and supervision as they mature. That's a big part of advocacy within the Oregon Sentencing Guidelines grid. If a loved one is facing an enhancement fact, that means the state's asking to double the grid block. And the state can seek up to double the grid block with an upward dispositional departure. And factors for upward dispositional departures are things like persistent involvement, defendant on supervision at the time, showed a lack of remorse. Those are the most standard forms of upward departures. We very rarely see people sentenced to upward departure sentences. Often it is a negotiation tool and an attempt to get people to plead to a grid block sentence. But certainly you're going to want to have any enhancement factor or upward departure reviewed by an attorney for you or your loved one. That's a little bit of the information about the Oregon Sentencing Guidelines grid. There are CLEs and conferences that I've been to that are hours and hours and hours about the various dynamics, the shift to I rule, the possible upward departure on a probation revocation and how probation revocations are sentenced. There's a great attorney, Jess Barton, who used to teach us all so much about sentencing, and I've seen segments that lasted hours and hours and hours. So we could talk about this for a long period of time. If you or someone you know is facing this situation, give us a call. And at the Law Office of Justin Rosas, we're happy to connect with you. And if you want more information about the Oregon Sentencing Guidelines grid, check us out at www.southernoregondefense.com. Thank you and have a good day.